Thank you for joining us. Today, Dayna, Bo, and Matthew will present on overcoming barriers to collaboration among behavioral health and primary care providers.
Hello, my name is Dayna Bowen Matthew, and I'm a professor at the University of Colorado Law School. I'm also on the faculty of the Colorado School of Public Health, and I'll be talking today about overcoming barriers to collaboration among behavioral health and primary care providers. To cover some preliminary matters, let me first say that my objective is to give you some tools and some recommendations, especially aimed at clinicians and healthcare professionals who are looking to collaborate within integrated care teams. I'll be focusing specifically on the HIPAA and privacy rules under federal law and some state law. A few disclaimers, of course, because I'm a lawyer. I won't be providing legal advice today. I will also be using the terms mental health and behavioral health interchangeably. And although there are many evolving models of behavioral health care integration in primary care, I'm actually going to be generally focusing on any models in which the doctor-patient relationship is replaced with a team approach to care, and care is stepped so that except for the acutely ill patient, healthcare providers offer care that is the least disruptive, least extensive, and least intensive in order to get positive results in a collaborative setting. So yes, I'll be talking about HIPAA, a dirty word for many of you, and I'm sure everyone in the audience is intimately, perhaps too intimately, familiar with many parts of this massive statute. It permeates your professional lives. But another one of my objectives today will be to remove some of the panic and the aggravation that you may feel from this statute, especially as it pertains to integrated care. So here's my outline. I'll review briefly the benefits of information sharing and coordinated care to make sure that we're all on the same page. Then I'll spend quite a good deal of time on the legal barriers to information sharing. I'll talk about some distinctions that are really important. First, the distinction between real and perceived obstacles, between state and federal obstacles. And I'll also hint that there are more obstacles than even those that I've touched on in the privacy realm. Next, I'll try and give you a little trip into the law school realm so that you'll understand the differences between state laws and how they originated, and then a practical checklist to get us out of the law school realm and back into the clinical setting. And I'll close with some ideas about what I call the long game. So let's get started. First, let me begin by discussing quickly the benefits of information sharing and what's accomplished with coordinated care. I'll do this pretty quickly. It's not difficult for any of us to imagine the need for coordinated clinical care, say for patient X, who's getting a range of services from Acme Hospital, maybe laboratory services, x-ray services, or other diagnostic care. Patient X is also an outpatient at Beta Substance Abuse Counseling Center, and also a patient at Cato, a federally qualified community health center. Let's say patient X is HIV positive. He also occasionally visits an emergency room at the hospital. The problem is that each separate provider provides discrete but connected services, bills for discrete but connected services, but we can all agree that this patient's care would be markedly improved if Acme, Beta, and CAPECO were all in communication with one another. So the solution, of course, is integrated care. The problem, though, is that the traditional model of behavioral health and of primary health is based on a completely different model. The barriers are significant. Time, of course, is a barrier. It's difficult to fit integrated healthcare into a 12.5-minute office visit. Silos are pretty prevalent. Professionals in both fields are used to and pretty much like their silos, I've found. Reimbursement and payment issues are in the way in a big way. There are barriers to paying for integrated care, especially in states like my home state of Colorado, where there are prohibitions, for example, that preclude reimbursement for same-day service by two providers. So we're going to focus on the laws that reflect the traditional model of behavioral health, where absolute confidentiality between therapist and patient is embedded in those laws, where absolute confidentiality between physician and patient are embedded in those laws. Those laws are disjointed and conflicting, and while I'm at it, before I go to the privacy laws, let me, as I said earlier, hint to the fact that it's not just the privacy laws that are in the way. There are building codes, licensing requirements that are disjointed and prevent coordination. For example, one type of mental health institution may be required to provide padding and handlebars to meet code for their facility, while another is not. Another state may not license addiction counselors in the same way that it licenses social workers who treat addicted clients. These disjointed regulations will end up requiring different disclosures, different reporting requirements, different treatment practices, different record keeping. It's a mess. But today we're just going to talk about those barriers that have to do with privacy and confidentiality. We're also going to talk about them under federal and state law. The state laws are particularly complex, and we'll hint at the problems that arise under the health information exchanges. So you know HIPAA. It's something that's familiar to you, but let me just rehearse the basics. It's a large federal law that basically maintains confidentiality and privacy of medical records. Think about HIPAA as a blanket of privacy that the federal government has laid across all 50 states. Internet, email, everything electronic. HIPAA essentially defines a floor. Let me repeat, a floor below which no state can go. The goal is to strike a balance that is by assuring an individual's health information is protected because, in the law's eyes, the individual patient owns that information. On the other hand, also to allow a flow of information needed to provide high-quality health care, and of course, to protect the public's interests. Well, you do know HIPAA, but did you know that in addition to HIPAA, in 1996, the federal government passed something called the HIPAA Administrative Simplification Act? Don't laugh. That act was passed by the Department of Health and Human Services, empowered the Department of Health and Human Services to improve Medicare where efficiency and effectiveness of healthcare systems are encouraged. That is, it encouraged the development of health information systems through the establishment of standards and requirements for electronic transmission of health information. Let me continue. Did you also know that the Health Information Technology for Clinical Health Act of 2009 includes basic premises that are intended to encourage information sharing? Specifically, that act provides billions of dollars of investment in health information technology in order to facilitate the exchange of patient information, while expanding the protection afforded by the privacy and security rules under HIPAA. HITECH, as this act is called for short, employs strong incentives and penalties for Medicare providers in order to incentivize them to actually use electronic health records, I'll call them EHRs from now on, in meaningful ways that favorably impact patient care. For example, HITECH develops standards to achieve certain technology for qualified electronic health records, demographic information, descriptive information that all healthcare providers have to share. And lastly, of course, the Patient Protection and Affordable Care Act. Underlying this act is the concept that integrated care is more efficient and favorable for the quality of care to patients. So the medical home is central to the ACA. Coordination of care is central to the ACA. The Medical Shared Savings Program for Accountable Care Organizations, or ACOs, promotes the implementation and widespread utilization of EHR among divergent providers. So why do I rehearse these three important and large federal acts? Just to let you know that the underlying intent of the three largest federal laws that pertain to information sharing is actually intended to encourage information sharing. But lawmaking is like sausage making. The devil is in the detail. Despite the fact that the broad underlying intent of these laws, as I've outlined them, is to encourage information sharing, there is lots that we have to be worried about. So here I'm going to make the different distinction between real barriers and perceived legal barriers. In fact, I've tried to make the argument that sharing information for the purpose of care coordination is a permitted activity, in fact, an encouraged activity under the largest federal laws that govern information sharing. So while HIPAA is often cited as a barrier to information sharing between primary care and mental health practitioners, this is not entirely accurate. Sharing information for the purposes of care coordination is actually a permitted activity, not requiring formal consents broadly. So let's begin with the information sharing that is permitted under HIPAA. Behavioral health records can be shared for treatment, payment, or healthcare operations under HIPAA. This includes medical sharing of a patient's mental health records if there is a treatment relationship between the patient and each facility. However, confidentiality laws that pertain to substance abuse, whether they're at the federal or state level, and mental health laws, most often at the state level, are generally more restrictive than those pertaining to physical health. So here I'll make the second distinction, the distinction between state and federal law. Remember in the introduction I said that HIPAA was a floor beneath which the states could not go. Herein lies the rub. In our legal system, there are two levels of law, federal and state law. The federal law, HIPAA, with which you're familiar, is generally the most lenient or, again, the floor beneath which states cannot go. The state laws tend to be the more complicated barriers that will prohibit information sharing. So returning to the federal law, PHI, that is personal health information, is permitted to be shared under HIPAA for treatment, payment, and healthcare operations. Treatment is the provision and coordination of management of healthcare and related services by one or more healthcare provider. I've just lost my slides. If you'll give me a minute, I'll bring them back up. By one healthcare provider with a third party. Other circumstances for PHI use or disclosure will require a patient's consent, and we'll talk practically about how that might be achieved. Now let me spend some time on a little divergence that is to take you to law school so that you can understand, looking at two cases, what the reason for these protections are. That is, what is the law thinking when it created these gargantuan statutes and these complicated rules that right now, well, in truth, stand in the way of integrated care. The first relevant case is called Jaffe versus Redmond. It's a case decided in 1996. It arises out of a constitutional challenge to a police officer's use of deadly force during a domestic violence call in the village of Hoffman Estates in Illinois. The police officer actually had undergone extensive counseling with a licensed clinical social worker after the shooting. The estate of the deceased filed a suit against the officer. The estate sought discovery of the therapist's notes for use in trial. That's where the privacy issue arises. The estate is looking to compel disclosure of the therapy notes after it had learned that the police officer had 50 sessions with a therapist. You can imagine how useful that would be in an excessive force case. Well, the court held no. These notes are protected as confidential. The court used evidentiary rules in order to reach this conclusion and analogized the privilege between a therapist and the police officer to the attorney-client privilege. Well, you can see how the law was seeking to protect the police officer's privacy. In our legal system, a case like this sets precedent when it comes from the United States Supreme Court. And it stands for the proposition or principle that will cover and influence all other legal interpretations. That is the principle that psychotherapy notes are private and should be protected by the law as privileged. The second relevant case is also of constitutional moment. It's a case that also reflects the traditional model of psychotherapy, individual patient, individual provider, lots of confidentiality protections. In this case, Whalen versus Roe, physicians and patients brought a suit to enjoin the enforcement of portions of a New York law, the New York State Controlled Substances Act. That law required that a centralized computer file containing the names and addresses of all persons who obtained certain drugs pursuant to a doctor's prescription be maintained. The drugs had a lawful and an unlawful market. Therefore, the purpose of the centralized reporting system was to prevent the illegitimate use of the drugs. That seems rational, right? But of course, the privacy issue is what we're concerned about. The question was whether the court could enjoin, that is, stop the enforcement of the New York law, and hold that portions of the law violated the plaintiff's constitutionally protected rights of privacy. In that case, the court held that the New York statute was constitutional, that it was fine. The law represented a reasonable exercise of the state's power and did not impair or in any way prohibit the right to practice medicine without interference. In explaining the privacy interest protected by the U.S. Constitution, the court said, these cases are sometimes characterized by protecting privacy, but they have really two kinds of interests. One is avoiding disclosure, and the other is protecting the provider. So those are the kinds of legal cases that set up the philosophy, the underlying premises, the precedents that control the HIPAA privacy rule. It's out of those views, out of those philosophies, out of those principles that HIPAA was actually enacted. So going back to HIPAA itself, of course, it limits the sharing of psychotherapy notes without a patient's written authorization. This will include any healthcare provider who is a mental health professional who is documenting, analyzing the contents of conversations. Recall the psychotherapy notes belonging to the police officer in the Jaffe case. This, on the other hand, will exclude medication prescriptions, monitoring, counseling sessions, start and stop times, modalities and frequencies of furnished treatments. These aren't protected as privacy. Think about the differences between this information and the information that was contained in the Whalen case that suggested these are discoverable or are not protected by the Constitution. HIPAA prohibits the sharing of medical information for many patients in alcohol and substance treatment programs that are federally funded. So let's go to those for a second. Federal regulations require reference a myriad of state laws that address confidentiality of these mental health and behavioral health records that particularly pertain to alcohol and substance abuse. They were promulgated by the Substance Abuse and Mental Health Services Administration, SAMHSA for short. They govern the confidentiality of these treatment and patient records for abuse programs. Federal law defers to these regulations that protect confidentiality. Behavioral health records are not inconsistent with the general HIPAA privacy rules, but the regulations, because they refer to a myriad of these regulations, also are conflicting. They are disjointed, and sometimes they are subject to different interpretations by different providers. I've put on the screen a link for the SAMHSA government privacy docs so that you can refer to the laws that pertain to your particular situation. It is possible that on the one hand, the regulations will prohibit sharing of information under HIPAA, while the state law will conflict. Unlike HIPAA, which generally permits the disclosure of protected health information without patient consent or authorization for the purposes we've already discussed, Part 2 of these substance abuse and mental health service regulations have some exceptions, but generally require patient consent for disclosure. So now I've described 3 different sources and levels of laws that pertain to privacy and confidentiality. It is important to check all 3 for every circumstance that you face. So HIPAA, the federal statutes that are the floor as I've described them, state laws, which are typically more restrictive for substance abuse and mental health standards, and lastly, this part of regulatory law that I've described regulations requires a lawyer. So it sounds like I'm giving you the Lawyers Full Employment Act explanation. But let me just tell you a little bit about what we call preemption in order to convince you that you should consult with legal counsel as you're navigating these 3 levels of rules. The doctrine I want to talk about a little bit here is called preemption. HIPAA is preemptive unless state laws or regulatory laws are more stringent. So HIPAA will preempt state laws that relate to the privacy of individually identifiable information if it is more rigorous or restrictive than the state law. On the other hand, HIPAA will defer to state law if that state law is more stringent than the HIPAA standard. So again, since preemption doctrine is mixed depending on the state that you are in, I hope I've convinced you that providers must check state laws, must check regulatory laws, and must consult with a legal professional in order to understand each one of these levels. State laws that control are widely variable. Even though I've referred briefly, for example, to the payment law that prohibits same-day prescription in Colorado, different states will have different laws that are different in their consistency within classes of healthcare professionals and different with respect to each of the regulations for HIPAA that are pertinent to any given situation. Let me turn just to one more level of complexity before showing you a few practical tips that could help you navigate this morass. Health information itself, health information exchanges themselves create some barriers. EHRs do not define psychotherapy notes components separately from medical records, even though HIPAA does. Physicians are not consistent in the way that they record information in EHRs. Vendors for EHRs do not keep up with the coordination of care reform or the separate state laws. Therefore, this represents yet another area for you to watch out, the health information exchanges themselves. They do support the broad collection of health information. They are a pathway to achieving real exchange of information, but they are not themselves directly under HIPAA's regulation. They're generally developed by third-party organizations like a regional information organization, and there are incongruities between the way that these HIE barriers operate or create barriers and the privacy rules that they individually follow. Therefore, let's go to a practical checklist for the practitioner who is interested in integrated care. First, you have to be mindful of the constitutional right to privacy, that right that was protected by the Jaffe and the Whaling cases. Understand the underlying protection that is of constitutional moment. It is profound. Then, of course, you have to look at the HIPAA regulations and HIPAA, the law itself. These are generally found in something called the Code of Federal Regulation, and they're pretty extensive. Then, of course, you have to look at Part 2, that substance abuse program regulation that I suggested. That's a third level of regulatory protection worth looking at. And even though I've listed here student campus health clinical records, what I mean to say is that's an example of electronic health information and health information exchanges that are important. Lastly, and definitely not least, check state laws. These will be found in state constitutions, in mental health record confidentiality legislation, in state drug and alcohol treatment legislation, and in disease-specific legislation, as well as specific case law. As a practical matter, it's always wise to ask every patient to sign a consent form upon admission. That means that you will be allowed to provide information in accordance with the minimum necessary rule. That rule means that only information that is immediately pertinent to the current treatment purposes may be shared. For example, mental health facilities can't fish around at hospitals or ERs for information about patients, like asking whether the patient presented at an ER after a suicide attempt. Secondly, as a practical matter, primary care facilities that are looking to establish integrated care could establish a business associate agreement. These are a way in which behavioral health organizations can qualify as business associates under HIPAA and share information for operational, not treatment purposes. You'll recall that for treatment purposes, both facilities have to have a patient relationship or a treatment relationship. Behavioral health organizations and their contractors are covered by federal HIPAA laws, and they can qualify as business associates. Thus, a provider that is a business associate can share information without violating HIPAA laws. There are other kinds of laws, such as organized healthcare agreements, that lawyers can structure in order to establish a relationship between different kinds of providers, mental health care facilities, mental health professionals, and primary care providers. There are state laws that are really progressive and that we could, when we look at the long game, anticipate advocates like myself and perhaps some in the audience seeking to change individual state laws. I'll close with an example. There's an Illinois example that is a great way to facilitate under state law information sharing. The Illinois law is found in Illinois Chapter 740, and it is called the Disclosure for Treatment and Coordination of Care. It's a sample act that every state could emulate and even improve on. It says that for recipients of a program administered and operated by, essentially, I'm skipping over some of the language, an integrated care facility, records of a recipient may be disclosed without consent by, and then it lists a series of organizations and entities that can share information. Surprisingly, under the Illinois law, these organizations include county jails, insurance companies, integrated health systems, state agencies, departments of children and family services, and only require the kind of justification that any provider and clinician would find reasonable. So I'll close by saying that although this is a very complicated area and you'll need some advice from a lawyer or a legal professional, the fact is that the law is supported by a general principle of encouraging and sharing information. We just have to get the details to catch up in the long game. Thank you.